But our big focus tonight, a big setback for the Narendra Modi government, the Supreme Court asking the centre to hand over all names of black money holders by tomorrow morning. The message from the top court was loud and clear. The government does not have to be a protective umbrella for foreign bank account holders. The Congress claimed vindication, but the government says it's more than ready to hand over the sealed envelope. The big question, will this disclosure really end the black money tangle? Jaskirat Singh Bawa, Ashish Mehrishi have our top story tonight.
The Modi government left red-faced, and that too on an issue that the Saffron Party had made into its big poll promise, getting back the black money stashed abroad into India. The Apex Court pulling up the Modi government, asking why only 3 of the over 700 names in the list have been revealed in its affidavit. Ordering the centre to reveal all names of Swiss bank account holders in a sealed cover first thing on Wednesday.
The court also said that these orders were passed in open court after hearing them. Thereafter, a review application was filed that was also that did not contain this prayer, etc. And now, therefore, there is no reason for modifying these orders.
Within minutes, the news of the Apex Court's rap to the government spreading like wildfire, the finance minister promptly agreeing to adhere to the court's order. But the opposition, in no mood to let the government escape so easily.
Since the government had already on the 27th of June given this list to the SIT, the government has no difficulty in placing the entire list, and the same will be placed before the court tomorrow.
आज क्या ऐसा कारण हो गया कि जो लॉ मिनिस्टर 2011 में एक बात कहते थे, वही लॉ मिनिस्टर बनने के बाद में अब उनकी कानून की व्याख्या दूसरी हो गई?
कांग्रेस वाले और अब बीजेपी की सरकार बनने के बाद बीजेपी वाले काला धन वालों को बचाते हुए नजर आ रहे थे, उनके नाम नहीं डिस्क्लोज कर रहे थे। जाहिर है कल पता चला कि जिन लोगों के नाम काले धन की लिस्ट में हैं, उन्होंने दोनों पार्टियों को चंदा दे रखा है।
Pradeep Burman, Pankaj Lodhia, Radha Timlu. When the government released the 3 names in the list on Monday, little did they realize its repercussions. The biggest irony, it's the Apex Court and not the government which has delivered on PM Modi's biggest poll promise. With Jaskirat Singh Bawa in New Delhi, Bureau Report, Headlines Today.
The big question, will the disclosure of all names really resolve the black money tangle? Right at the top, I spoke to our newsmaker this evening on that big question. Mukul Rohatgi, Attorney General, someone who's appeared in the court for the government. I began by asking Mr. Rohatgi, would he concede that what the Supreme Court had done today by telling the government that all names had to be given to the court, was it embarrassing? Had the government been left red-faced by the Supreme Court's order this evening? Listen in to what Mr. Rohatgi had to say.
This government does not wish to hide any name whatsoever from the court. All the names which are in excess of 600 in the list has already been shared with the SIT on 27th of June this year, and the investigation into all those names is presently ongoing by the IT department under the supervision of the SIT, which is an appointee of the Supreme Court headed by 2 judges of the Supreme Court. Therefore, once we have already shared the same names with the delegate of the Supreme Court, where is the question of reluctance in sharing the names with the Supreme Court?
But I'm going to ask you this, Mr. Rohatgi. Am I to understand, therefore, that as far as your NDA government is concerned, your stand has not changed? You believe that only those names should be revealed in public against whom there is prosecutable evidence, against whom prosecution has begun. Is that still your government stand?
The government stand has not changed. That is the perception of the legal treaties which we have entered into on a sovereign basis between this country and other countries. All the treaties have more or less a uniform clause that without probing or verification, all accounts should not be made public because right of privacy is involved. And I must tell you, Rajdeep, in the main judgment delivered in the year 2012, the court itself exempted the Government of India from disclosing names without verification. Because you must understand that merely because you happen to have an account abroad is not per se illegal. People can have genuine explanations in having monies in a genuine account. Therefore, their privacy is required to be protected, not only in terms of the Indian Constitution, but also in terms of the clause of the treaty, and which is common in every treaty.
You know, I take your point, but are you then worried that given what the court has told you, disclose all the names, give us all the names, are you worried that that very privacy of people who may have legitimate foreign bank accounts will actually now be exposed to public scrutiny? That I may have a legitimate account, foreign bank account, and yet my name will be in this list and will be in the newspapers come tomorrow or day after tomorrow.
Now, Rajdeep, the Supreme Court has asked me to give the entire list to the Supreme Court at 10:30 tomorrow morning in a sealed cover. So I will give it in a sealed cover to the court. The sealed cover means that they will be in custody of the court and will not be made public unless the court so directs. It will be my plea in the court that these should be kept in a sealed cover, failing which we will be willy-nilly breaching the clause of confidentiality, including the fact that we have to enter into a huge treaty with the US next month, which will provide for the first time on automatic basis all information of Indian residents in the US having accounts and vice versa.
But Mr. Rohtgi, will you be making a distinction when you provide that evidence in those, or provide those names in a sealed envelope, come tomorrow morning to the Supreme Court, will you make a distinction between those who have illegal accounts, who you believe have stashed away illegal money abroad, and those who will claim to have legitimate foreign accounts? Will you be informing that to the court as well?
In the sealed cover, we are not making any distinction. We are giving the list as it is. The list is presently under probe. It is not possible to probe till the end about 600 and odd accounts in a few months, because investigation is a lengthy process. It can't be done in a few days, because at times the information is sketchy, at times the addresses are wrong, etc., etc. Therefore, the list goes as it is, but I made clear to the court the distinction between two sets of accounts, as you have rightly mentioned, and the court is aware of these two sets.
But let me tell you, Mr. Attorney General, where the problem comes. The fact is that there are more than 700 names apparently that you have with you. Of that, you very selectively, some would say, revealed just 3 names only yesterday. Many believe that this was either done as a damage control measure because you were under pressure from the court. You revealed 3 names which really seemed like small fish. And that leads to the suspicion that the government agencies who should be investigating these 700 names are moving very, very slowly, which is why the court has now decided to intervene.
No, Rajdeep, understand that out of those 3 names, one name came from another country, which is not a part of this 600 names. Now, if 600 and odd names have to, be probed starting from, say, July of this year, the investigation starts with a show cause notice. A person has a right to give a reply. First, we have to trace the person. At places, the address may not be correct. At places, people don't live in India, though it may have an Indian address. So it takes time. And then a person responds and gives his justification. And if we find that the justification is proved to be totally unsatisfactory, then we add that money which is kept abroad into the Indian assessment in regard to that person. So assessment takes place, penalties are added, and then finally prosecution occurs. So once this process is complete, it's bound to take some time. It's not a matter which can be done.
No, Mr. Attorney General, I can understand it takes some time, but look at the duration. HSBC accounts come in 2012 to your government. I mean, the previous government, some would say the UPA government, but governments are governments. The political party may change, but government is a continuum. The Enforcement Director and Income Tax should have been acting in 2012. The Liechtenstein Bank accounts came at the same time. Why should it take so long for the Enforcement Directorate and IT to then come out with just these three names? That is where the suspicion is that the government has something to hide. Whether it's the previous government which dragged its feet on it, or whether it is this government which in the last 5 months comes up with just three names.
See, as now, Rajiv, I can only answer for this government because I also took over in the end of June. As far as Liechtenstein accounts are concerned, there were 26 in number, 18 were found to be illegal, 6 were found to be legal. So 26 in 2 packets were disclosed to the Supreme Court, and they form a part of the verdict of the Supreme Court dated 1st of May 2014. In regard to Liechtenstein, all accounts are in public domain. That chapter is over. As far as this list is concerned, investigation is ongoing. The result of the updated investigation is also being put by me in the sealed cover for the Supreme Court to examine.
But let me again play devil's advocate and reveal the suspicion that people have. Do you really think that simply putting out these names in either in the public domain or in a sealed envelope is going to result in recovery of money, is really going to speeden up the investigations, and see whether really big names are going to come out? There is a lot of skepticism about the way this investigation has gone on.
See, Rajiv, my answer is I am also an optimist. I think something will come out of it. At least there will be a great deterrence for people in removing money clandestinely from this country, number one. Number two, I don't know whether there are big names or small names. We are making no distinction. All the names in the entire list, and the list as it is received is being given to the Supreme Court. Whether black money can actually be brought back or can only be taxed in India and recovered is a question which only future can answer. I can't say.
It's interesting, as a lawyer, you seem to be playing down expectations, because the same party, when it was in the opposition, said, the BJP said, we will bring back money within 100 days, we will reveal all these names, which is what even the likes of Mr. Ram Jethmalani now say. The government promised a mountain and is now producing a molehill. How do you respond to those who are being skeptical about the way this entire exercise is being carried out, Mr. Rohtgi?
There is no question of a mountain or a molehill. Entire investigation is ongoing. Wherever the accounts are found to be illegal, there will be prosecution here. Income tax will do the prosecution. Getting that money into India is yet another cup of tea. That's not the question today. And I may tell you one thing. Yes. If we are unable to adhere to the clauses of confidentiality and unable to enter into fresh treaties, we will be in breach of our obligations to the international communities, international countries, other countries, international fora. And if that happens, then the information will dry up and will actually become anti-black money crusade rather than a black money crusade.
That's interesting, because many would say that you're pointing out to some of the limitations that exist. Are you going to assure our viewers also here that there will be no political pressure on the Enforcement Directorate and the Income Tax while they carry out this investigation?
Let me tell you, the SIT was constituted by this government after it came to power in May. The first cabinet meeting constituted the SIT. The list was immediately shared with the SIT. SIT is an appointee of the Supreme Court. We are working closely with the SIT, and I assure you and your viewers that this government will not put anything under the carpet. All names will be investigated without fear or favor. There is no question of big name or small name. There will be no cherry picking, but it is the duty of every department, whether IT or whether ED or anybody, to first examine whether the account is illegal or not.
No, I
That
take
is
your
the
point. I take
perception.
your point that it is the duty. I agree with you that the process is that the IT and ED have to investigate whether the account is legal or not. Many believe that most of the big names don't even have the accounts in their own name. A really big money person who has a big foreign bank account will never keep it in his own name is the belief, which is why the fear is that this is going to drag on. Therefore, can you give me a time frame? How long will it take? 2 months, 6 months, a year? How long will it take for the Enforcement Directorate, for the income tax to really reveal to this country who are the individuals who have illegal foreign accounts?
Rajdeep, it will be hazardous for me to guess because I have not asked this question and I have not seen the actual investigation done in the last few months. But I am sure if it is between 6 months to 12 months, a very sizable amount, if not the entire, will surface.
Okay, 6 months to 12 months is what you are promising.
Thank you.
Attorney
Bye-bye.
General,
Good night.
6 months to 12 months. Mukul Rohatgi joining us here at the top of News Today at 9, giving us where the government stands on the black money issue. But I want to carry forward that debate and look at the politics behind it. Is it now becoming therefore a political game? What will really happen as a result of these names being provided to the Supreme Court? I'm joined by a special panel. I'm joined by Sandeep Bamzai, editor of Mail Today, who tracks the entire issue. I'm also joined by Seshadri Chari, National Executive Member of the Bharatiya Janata Party. I'm also joined by C.R. Kesavan, spokesperson of the Congress, and Mr. Ved Jain, former president of the Institute of Chartered Accountants of India. Sandeep, before I come to the politicians, you heard the Attorney General saying that the government needs to follow due process, essentially, saying that, look, we cannot be going around putting out names in the public domain of people who have foreign bank accounts. Some of them may be legal accounts. Do you believe that that stand of the government is valid? And therefore, has the Supreme Court overreached itself in asking, please give us all the names. We may put out all these names tomorrow in the public domain.
Three things. One, what constitutes black money? Every Indian individual is permitted by the Reserve Bank of India to transfer up to $125,000 per year, which means a family of 4 can actually transfer. And when
by informing the RBI.
Following due process, you can buy property abroad, you can buy shares abroad, you can buy securities abroad, you can buy art abroad. $125,000 per individual per year means the family of 4, 500,000 USD, which is 3 crore rupees. You can buy a property overseas for that much money. This is A, part A. Part B, which is what the question that you just asked Mukul Rohatgi. You kept asking him about the Enforcement Directorate's role. Let me tell you, as of today, as we speak, as we sit here, the Enforcement Directorate has nothing to do with this investigation.
The Enforcement Director of the country.
The Enforcement Directorate, which has domain expertise and domain exclusivity on Prevention of Money Laundering Act, PMLA, and FEMA, it has never been approached by any government.
So these 700 names have not been...
Three. There are no 700
No,
names.
the original SIT, the SIT, the claim was that there was 700 names. Is that also a fiction?
No. In January 2013, in January 2014, this year itself, HSBC handed over a list of 628 individuals and entities to the Department of Income Tax, India.
Yes.
The Enforcement Directorate this list has never been shared with the Enforcement Directorate.
Even though they have the domain expertise.
It's never been shared with them. Never, ever. So, 628 individuals and entities who are believed to have illicit wealth in HSBC. Now, how did this come about? There was an individual called Hervé Falciani who actually turned out to be somebody who stole this data and then sold it to others, just as Heinrich Keiber had done it for the LGT Bank.
Are all those 600 odd illicit foreign money, are all this, should that be investigated? If the Enforcement Directorate, you're saying on this program, has not even begun investigation, then what is the government telling us today?
So here is the thing, that for a long time, and for most of the time, the Department of Income Tax has proved to be the nodal agency in this matter. The Enforcement Directorate, now I believe, the Special Investigative Team which has been constituted by the Supreme Court, has said that the Enforcement Directorate should now be the nodal agency for this probe. All these days, the Enforcement Directorate, even the Liechtenstein list was never shared with the Enforcement Directorate. Forget the Falciani list from the HSBC Bank.
You know, Mr. Jain, I'm seeing you smiling while you're hearing that. This then seems, if what Sandeep is saying is true, if the Enforcement Directorate with the domain expertise of looking at whether people have illegally stashed foreign money abroad has not even been approached as yet to begin investigation, what are we talking about? Simply handing an envelope with 700 names to the Supreme Court is not going to bring back the black money back to this country.
But Rajdeep, then we cannot fault X and Y for this. We need to understand that this process remains incomplete over a period of time.
I agree. I'm not getting into the political blame game. I'm just trying to understand the process.
Nobody has bothered to do anything about this.
I'm trying to understand the process. The process in this country surely is that you start an investigation first.
See, Rajdeep, let me first clarify what is the legal position. So let's just give me a few minutes on this issue. See, in 1934, Switzerland started the secrecy laws. And till 2009, Switzerland was enjoying all these secrecy laws. And there was no hue and cry on these secrecies. In 2008, when the Lehman Brothers happened and all these UBS issues happened, then the first debate started that the Switzerland should start, the bank should start sharing the information. There was a strict law in Switzerland. Anybody sharing the information, bank account, etc., there was a criminal prosecution for the employer, whosoever is there.
Yes.
In 2009, we started a debate. Meanwhile, India has been signing and all countries have been signing double taxation avoidance agreement, whereby there is an exchange of information between the different countries. This treaty is being signed on OECD guidelines. There is an Organization of Economic Cooperation and Development. They signed the treaty. Under that treaty, exchange of information takes place, and then one of the conditions of exchange of information is that this information is being shared exclusively for the purpose of tax. And only when the text you had happened that there is a criminal prosecution having been launched, that information can be used for other purposes. Whatever the information now the Supreme Court is talking and the debate is going on, we need not politicize it. We need to depoliticize it.
You need to depoliticize it. You need to only focus on whether there is actual tax evasion.
Yes. Now the question is, Germany has shared the information with India.
Yes.
And it has said that this information has been shared under the tax exchange program. And there is a strict prohibition that no agency, including the Enforcement Directorate, can have an access to this information. This is a condition.
But there's an SIT which has been appointed.
Coming to this.
By the Supreme Court.
So SIT was constituted in May by this government immediately after it took it over. And SIT is seized of this issue. And if you look at the report around, SIT says that now we are looking at the tax treaties, how we can resolve this entangle which has been created.
Yes.
Now, India cannot create a problem in the international law where they say we defy the international law and disclose this
name. There's a UN Convention on Corruption. The apex court of the country wants the names of all the individuals. The treaty, you say, prohibits the government from revealing those names in public unless there is prosecutable evidence that they have avoided tax.
Yes.
Right?
Yes.
So you're saying, therefore, the Supreme Court would be going beyond its jurisdiction?
No, I have two considerations. I have two considerations.
Yes.
I will just recall in the year 2012, we did one act which affected the economy like anything, whereby we overruled the Vodafone judgment and we lost the confidence of the international investor.
The retrospective tax amendment.
In case the India does not follow the international law, and whereas information which the government has obtained under a commitment that this is meant for tax people only and it will not be shared with other agencies, and if India does share with the agency, that we are losing the confidence of the international.
Let me before I come back to Sandeep, therefore ask the politicians, are you politicizing an issue where here is an expert on chartered accountancy, here is someone who tracks the issue saying depoliticize it. Let's look at it purely objectively in terms of what this is all about. Mr. Seshadri Chari and Mr. Kesavan, is there a fear, Mr. Chari, that both sides have politicized it? You in the run-up to the 2014 campaign said reveal all the names of the black money holders. The government is hiding the names. Today, once you are in government, you have realized that there are obligations that any sovereign government has with when it signs treaty agreements. You politicize the issue. Now the Congress is politicizing the issue, saying the government has something to hide. In the process, we will really not come to the nub of the problem, which is we need to get the monies back and we need to find who are the people really who have illegal bank accounts. Are you politicizing the issue deliberately, Mr. Chari?
No. No, try to understand one thing. I'm not going into the legalities, I'm not going into the technicalities of this issue, because there are two experts to do on that. But there was a perception that UPA government is not coming out with the names. And if you go by what Mr. Jain and Mr. Bamzai said, as far back as 2011, Mr. Jain would correct me if I'm wrong, the Supreme Court wanted all the names. But the UPA government tried to circumvent that issue and tried to go to public and also get that particular ruling of the Supreme Court reversed in such a manner that we have the names but we will not give. A. B. We will not conduct any further investigation with any country in this world whereby we will get the names. After the
UPA claims on their side claim that they have signed bilateral treaties with different countries to ensure. No, but the point is
HSBC list also came now.
Let's today avoid all the
difference calling. No, the difference is Supreme Court wanted this list. We are handing over the list to the Supreme Court.
Yes.
And the Supreme Court knows its rules and regulations. They know their limitations.
I am worried that the Supreme Court is being driven again by politics and maybe by screaming on television channels, Mr. Keswan, because my worry is that the Supreme Court believes in some way that by handing over these names to the Supreme Court in a sealed envelope, black money will magically be recovered by this country. It's not going to happen.
That's not coming back.
Shouldn't the Supreme Court be focusing?